If everyone could find a seat, please. Find a seat if you could, please. If everyone could take a seat, please. We're going to get started. There's plenty of seats here in the front if people want to make their way to the front. It's an excited crowd. Welcome, everyone. Slowly, the crowd quiets. Thank you, Michael. My name is still Dean Reuter. I am almost tired of saying that, but welcome to the Robert H. Bork Memorial Lecture. I want to begin, if I could, with a show of hands. So a quick show of hands. How many of you are satisfied being here at the Washington Hilton Hotel? Okay. How many of you are grudgingly satisfied being here at the Washington Hotel? Wow. That's some valuable information, but I was able to see hands on the first question. No catcalling. This is a show of hands. Do you understand show of hands? All right. Well, that's good information for us. Now here's some information for you. The next National Lawyers Convention has already been scheduled. It is November 6th through the 8th. So mark your calendars, November 6th through the 8th. Somebody said that's early, and I'm well aware of that because we have one less week to plan it. It will be here at the Washington Hilton Hotel. This is a tough crowd, you know. Now, let me begin to introduce this lecture, if I could. We're excited to be hosting, of course, the annual Robert H. Bork Memorial Lecture, and now turning to Robert Bork's legacy for a moment, if you'll indulge me. I know everyone in this room as a lawyer knows that it would be a great thing for you professionally if during your lifetime as an attorney or legal scholar, you could revolutionize not only how the legal and policy world think about antitrust, but how they do antitrust. That would be just an enormous impact in a significant area of law that I couldn't even fathom if I had a role in that, the role in that. But likewise, it would be a remarkable thing to become known as the preeminent scholar, the preeminent thinker in administrative law, such an important area of law that seems to become increasingly important with implications for separation of powers and limited or unlimited government. But to do both, to have huge impacts in antitrust and ad law, that would be truly astounding. But certainly, of course, it would be impressive if during your lifetime you raised and then firmly planted the banners of originalism and textualism in the legal landscape. If you revolutionized the way lawyers think about the written word. But to do all three things, revolutionizing antitrust, administrative law, and originalism and textualism, all three, that's almost otherworldly. I would say it's impossible, but we all know Judge Bork did do these three things and much, much more. In addition, he was a friend of the Federalist Society, and his memory and legacy will endure within the DNA of this organization for as long as this organization exists. So we are very pleased and honored to carry on the tradition each year to recognize his contributions to us and to the country. I now want to recognize members of the Bork family who are able to join us today: Bob Bork, his son, his wife Diana, and their daughter Claire. Thank you for being here. We're honored to welcome our speaker for today's lecture, Professor Stephen R. Sachs. Professor Sachs, aptly, is the Antonin Scalia Professor of Law at Harvard Law School, where he teaches civil procedure, conflict of laws, and seminars on constitutional law. His research focuses on the theory of constitutional interpretation, the jurisdiction of state and federal courts, the history of procedure in private law, and the role of the general common law in the U.S. legal system. He's authored numerous articles, essays, and book chapters. He's also an elected member of the American Law Institute, an advisor to ALI's project on the restatement of law, conflict of laws, a member of the Judicial Conference's Advisory Committee on Appellate Rules, and a founding member of the Academic Freedom Alliance. Professor Sachs, we're so pleased to welcome you here today.
Thank you very much for that kind introduction. I am honored by your confidence in being invited to speak here today. I am honored by all of you taking time out of your afternoon to come hear me. I apologize that I have no champagne to offer. And I'm honored by the decision of some of the students at my law school, some of whom are here today, to choose me as their advisor. And I'm honored to give this lecture named for Judge Bork, whose work served as part of the foundation of modern originalism. This conference has discussed the theme of group identity and law. And I would like to speak today on two not entirely unrelated issues of group identity and the Constitution, as inspired by some of George Bork's work. Much of politics is identity politics, and it has been for a very long time. There was never a point in our history when questions of identity didn't matter for American politics or American law. And that is true not only of familiar categories of identity, such as race or sex, but also of ones that have declined somewhat in influence over time, such as region or religion, and new categories of education and credentials. So I'd like to speak today about two very different problems, some posed by the past and some posed by the present. First, about the problems posed for our constitutional tradition by those divisions most salient at the founding. And second, about the problems posed for our constitutional tradition, but also for good governance more generally, of some divisions becoming newly salient today. In both cases, the Constitution isn't a full answer to social divisions, whether at the founding or today, and indeed it doesn't try to be. Rather, it's an attempt at a modus vivendi, a way that deeply divided people might seek to live together. The divisions that we face now are new in every era, and the difficulties that they pose for constitutionalism are novel too. But the Constitution has some role to play in how we respond to them, and organizations like the Federalist Society have some role to play too. We can frame the first problem by discussing then Professor Bork's famous 1971 article on neutral principles and some First Amendment problems, one of the seminal works of modern originalism. In that article, Bork considered the view that courts generally, and the Supreme Court in particular, needed to make choices of fundamental values. Bork argued against this view as inappropriate for a democratic society. Where the Constitution does not embody the moral or ethical choice, he wrote, the judge has no basis other than its own values upon which to set aside the community judgment embodied in the statute. That, by definition, is an inadequate basis for judicial supremacy. Now, it's possible to read this passage as morally relativist, and of course, Bork was not. For this purpose, he didn't have to deny that questions of value can have better or worse answers, or that judges, like other people, can sometimes tell which is which. Instead, he needed only to recognize that people regularly disagree on which answers are better or worse, and to invoke what he called the presuppositions of a democratic society, in which the people, by and large, get to decide which answers they trust. In that kind of society, the officials, including the judges, have only as much authority as the people have given them. If the people never gave their judges authority to make certain moral and political decisions, then the judges can't make them, no matter how good their moral and political judgment might be. The response to the Supreme Court's making moral and political choices then might be, who do you think you are? Not just in the rhetorical sense, but literally, who do you think you are? What is this Supreme Court of which you speak? When we need to settle questions about the Article III Court's own composition and membership and structure, we look to the Constitution and to the laws made in pursuance thereof, just as we do to find out these courts' powers or the substantive rules they're supposed to apply. The theories of judicial supremacy that Bork saw around him are theories of a very strange world in which Article III is in the Constitution, but nothing else is. Instead, as Bork pointed out, rather than claim authority to make moral and political choices on their own, our courts themselves regularly acknowledge the authority of the founding instead. As he wrote, the Supreme Court regularly insists that its results, and most particularly its controversial results, do not spring from the mere will of the justices in the majority, but are supported, indeed compelled, by a proper understanding of the Constitution of the United States. Value choices are attributed to the Founding Fathers, not to the court. The way an institution advertises tells you what it thinks its customers demand. Now, for myself, I would use slightly different language. To my mind, the founders chose not values, but rules of law. The Commerce Clause does not say regulating commerce is very important. Instead, it describes a specific power and commits it to a specific body. But the intuition is the same. In our system, we take the Constitution's enactment as having made certain decisions, and we take those decisions as revisable only via certain means. And these expectations are made themselves more visible by just how loudly the court keeps proclaiming them whenever it's doing something fishy. The Supreme Court does not claim an institutionalized role as tribune of the people, let alone, as Bork put it, as perpetrator of limited coup d'etat. Instead, it only claims the role of enforcing decisions already made, including the past decisions that give it something to decide. But this brings us to the first problem that I mentioned above. Those decisions or those value choices made by the founders have only as much authority as we give them today. And that authority is, perhaps, on the wane. A few years ago, a colleague asked me, with real concern, though he was not an originalist himself, how is originalism supposed to survive, given that we no longer think of the founders with respect? Similarly, at an event in 2021, NYU law professor Kenji Yoshino reportedly asked Justice Sotomayor whether originalism would become increasingly untenable as the country's demographic makeup continues to depart substantially from the makeup of the framers. Justice Sotomayor, it was reported, thought it a fascinating question whether and how her colleagues' use of originalism will lead to dissonance between what we are deciding and what the general population accepts as to what the law should be. Indeed, a criticism of this kind appeared in the joint dissent in Dobbs. Justices Breyer, Sotomayor, and Kagan pointedly noted that, quote, the people did not ratify the 14th Amendment, men did. Those responsible for the original Constitution, they wrote, including the 14th Amendment, did not perceive women as equals and did not recognize women's rights. When the majority says that we must read our foundational charter as viewed at the time of ratification, they concluded, it consigns women to second-class citizenship. So this is the first problem posed for our constitutional tradition that I'd like to discuss. If Americans no longer see themselves in the founders as they once did, what does that mean for our use of the founders' law? Why should the 200-year-old decisions of a bunch of white male property owners, indeed many of them slave owners, have binding force for us today? If the idea of originalism is restoring some past world or past consensus, then why should those who were excluded from that past consensus, for whom, as Columbia professor Jamal Green has written, a narrative of restoration may be deeply alienating. why should they be expected to play along? I don't mean in any way to understate the force of this critique, which I see as quite serious. What I do want to emphasize is the way in which it's really more about the present than the past. The claim that we can't see ourselves in the founders has more to do with modern identity than past exclusion, with who is on the outs now, and not necessarily who was rendered voiceless then. Consider the way that it's sometimes framed, that had I lived back then, I wouldn't have been able to vote. Let's spell out that counterfactual. Who is the I who would have lived back then? For example, while the US Constitution banned religious tests for federal office, in many places Jews could not hold certain state offices, and in some places Catholics couldn't either. The 1776 North Carolina Constitution, for example, provided that no person who shall deny the being of God or the truth of the Protestant religion shall be capable of holding any office or place of trust or profit in the civil department within this state. I lived in North Carolina for a decade. I now live in the Commonwealth of Massachusetts. And in one sense, had I lived back then, being Jewish, I could not have been a member of the Massachusetts legislature that voted on ratifying the Free Exercise Clause. In that sense, the people didn't ratify the First Amendment either. Protestants did. But we still think that the First Amendment has force for us today, and not just for Protestants. Now, I am not trying to argue by any means that Jews, Catholics, and African Americans were all equally oppressed at the founding. I think that would be absurd. What I am trying to argue is that the reason we today see some of these exclusions as less meaningful and other exclusions as more deeply painful is not just because of the depth of those exclusions in the past. It's also because of our beliefs about those exclusions today. In modern American society, Jews and Catholics have not usually been on the outs. Today's society is not nearly so stratified along religious lines as it used to be. So many people don't think of these past religious exclusions as deep features of the founding that require drastic modern remedies. So too, one would think, for the injustices worked by the Chinese Exclusion Acts. But other social distinctions of race and sex may be very much still with us, and so many people see these divisions as dividing us from the founding generation. That doesn't make these divisions less real, but it does show that our task is to lessen the divisions today rather than to attempt to go about fixing the past. That these concerns are about the present and not the past also explains why we don't worry very much about playing the counterfactual forward. Arguments about voting restrictions at the founding generally aren't designed to promote a specific package of legal rules that would have resulted had our past society been more just. For example, and as I argue in a forthcoming article, to its founding era critics, my colleague Michael Klarman argues, the Constitution was seen as a white male elite project, a scheme to favor the mercantile interest, some backcountry farmers thought. In that case, more universal suffrage on grounds of property ownership as well as race or sex might well have led to no Constitution at all, or else to something closer to the Articles of Confederation, with many fewer powers for Congress and many fewer limits on the states. Remember, in an era of fugitive slave acts, plantation owners might often have taken a broader view of inherent national authority than those whom they enslaved. Political parties and interest groups flip-flop on federalism every day, so there's no reason to suspect that ordinary Americans would, by virtue of their race, have held any consistent views on federalism across the centuries. If we want to resolve these divisions, one might then conclude, we should focus on the actual concerns of actual people today, instead of symbolically incorporating the hypothetical opinions of other people who kind of resembled them 200 years ago. In some ways, this problem is very familiar. As Green notes, any constitutional theory needs to think about the dead hand problem, why the decisions of people more than 200 years ago, all of whom are now long dead, are binding on their own descendants. And any theory adequate to deal with that problem will usually be adequate to explain why those decisions might have authority for the descendants of others. At the founding, roughly half of my children's ancestors were somewhere in Eastern Europe, we don't know where. Another portion were in Western Europe, some were in the American South, and some were held in slavery, either in Puerto Rico or what's now the Dominican Republic. Almost none of them, even the men, were consulted in forming the Constitution. But almost none of them would have shared my children's views and interests either. What really seems to matter in deciding whether people at the founding were or were not like me is not whether they shared my social characteristics, but whether they shared my views on questions of importance. But as Chris Green notes, what would the framers do if they agreed with us about everything is just another way of asking, what would we do? And we do not need a constitution to tell us that. Instead, when my ancestors came to the United States, they chose to join its society and accept its citizenship on its own terms. Likewise, the extension of the right to vote on the basis of race in 1870, of sex in 1920, to Native Americans in 1924, and so on, did not erase all past injustices, but the acceptance and use of that right did represent a claim to membership in an existing polity with existing law, rather than an effort to replace that polity with something new. Law is always backwards looking in that way. As my old boss, the late Judge Williams, once pointed out, at least until we devise time machines, a change in law can only have its effects in the future. Enacting a law does nothing at all, unless it is applied by people in the future who will treat it as part of their legal past. Treating past law as staying law until it's lawfully changed gives current lawmakers a very important power, namely the power to leave things alone. And it lets us impose conditions on when we do change the law, reassuring those who lose an election or two by requiring a very broad and formal consensus for fundamental change, say 2/3 of each house and 3/4 of the states. We can see this most clearly in imagining how our system might work if it didn't require that kind of reliance on the past. As Georgetown professor Louis Michael Seidman has put it, instead of arguing about what is to be done, we argue about what James Madison might have wanted done 225 years ago. To Seidman, we should instead rely on a network of customs, rules, precedents, and legislative texts, which can be disregarded when advocates persuade people that they are unjust, ineffective, or outdated. Or consider the argument of Yale professor Samuel Moyn and my colleague Ryan Dorfler that we should adopt a system of legislative supremacy, doing politics through ordinary statute rather than fighting over who controls the heavy weaponry of constitutional law from the past. If legislatures just passed rules and protected values majorities believe in, they argue, the distinction between higher law and everyday politics effectively disappears, and we could have the present electorate decide on fundamental values like racial equality or environmental justice. The difficulty here, as others have pointed out, is that even legislative supremacy requires some higher law. In order to know really, who is this Congress of which you speak? We need some rules governing Congress's composition and membership, rules that we currently take from the Constitution, just like all of the rules specifying which powers belong to this Congress and which belong to other bodies. A world of legislative supremacy is, like I said above, a very strange world in which Article 1 is part of the Constitution but nothing else is. And this problem shows up in spades when we imagine with Seidman relying instead on a loose network of customs and precedents, a sort of British unwritten constitution for the United States. The British have parliamentary sovereignty to make that system work, but we don't. A world with no written constitution, but with conflicting centers of power in the states, the White House, Congress, and the court is very hard to get right. What, for example, prevents the current president-elect from running for a third term in 2028, other than an antiquated constitutional text? Or as Seidman might put it, what Earl Michener and Robert Taft wanted done 77 years ago. The point here isn't that originalism is the only way of running a legal system. The point is that the dead hand problem is a problem, regardless of what legal system you use, because the people cannot always be assembled. There must be some way that the legal system acts, and also some way, whenever it isn't acting, that we identify the law that was made the last time it acted, even in the benighted past. And as it happens, other than originalism, there is no way that we here happen to recognize of fully acknowledging a change in our fundamental law. There are plenty of rules that one might call black letter law today that are not in the original Constitution. Growing wheat in your backyard is interstate commerce, say. But, here that's a laugh line. But no black letter rule about how those rules get to be black letter law other than Article 5. And even the court that decided Wickard v. Filburn had to claim that its decision followed naturally from the Constitution. Indeed, that it was, quote, a return to the principles first enunciated by Chief Justice Marshall in Gibbons v. Ogden, a mere application of the Constitution's timeless principles to present facts. And that is why the Dobbs dissenters' response was not to get rid of the male-ratified 14th Amendment, even though its ratification was in fact opposed by early feminists, because its Section 2 protected suffrage for male citizens only. It was the first use of the word male in the Constitution. Neither did the dissenters read the amendment counterfactually to imagine what it would have said in a world where women had participated fully, but the amendment passed nonetheless. Instead, the dissenters' response was to apply the amendment by what they claimed to be its original terms. By happy coincidence, they argued, the male framers of the 14th Amendment had not defined rights by reference to the specific practices existing at the time, but rather in general terms to permit future evolution. If that were true, then the question for us today would be the correct application of those general terms to present facts. But of course, whether it is true, or whether the 14th Amendment codified past rights rather than evolving new ones, is a question that can only be settled as a matter of original history by correctly understanding which rule its actual framers and ratifiers wrote down. Now, the legal validity of these rules is one question. Their binding authority in our consciences another. But we who value the society in which we live and who intend to treat those who live here with us as our fellow citizens, notwithstanding our divisions, may have good reason often to treat as law what is widely acknowledged as law, including what is widely acknowledged as the exclusive means of legal change. And that is true even if our law today is not what we would like it to be, or was made long ago in a way that it should not have been made. Remember, for all of the limits on the franchise that attended its adoption, the Constitution itself was not made by a homogeneous group of rich white men who already agreed on everything. It was made by an extremely heterogeneous group who disagreed hotly on all sorts of things, including on the evils of human slavery. And the reason that it has worked as a modus vivendi for so many years, to the extent that it has, was that it was mostly able to channel disagreements like these in productive ways, encouraging people who wanted fundamental change to convince broad swaths of their fellow citizens, rather than just to win the next election by a margin of 50% plus one. In a polarized era, though, the idea of persuading broad swaths of one's fellow citizens to do anything important may seem impossible. And so this brings us to the second problem, not just of divisions that have been salient for centuries, but divisions becoming newly salient today. Return to Judge Bork and his paper on neutral principles. Bork had looked around him in 1971 and seen a judiciary unable or unwilling to defend its claims on solid intellectual grounds. Cases like Griswold v. Connecticut, whatever one thinks of their outcomes, were failures simply as a matter of legal craft. As he described it, Griswold was an unprincipled decision, both in the way in which it derives a new constitutional right and in the way it defines that right, or rather fails to define it. The court soon followed up Griswold with Baird v. Eisenstadt, in which it announced that if the right to marital privacy that was announced in Griswold means anything, it applies equally to, quote, the individual, married or single. As was noted by my former colleague, Jeff Powell, this is a claim that cannot be made, quote, with a straight face and expecting to be taken seriously. The difference between reasoned judgment and authoritarian diktat has become obscure. The growth of modern originalism, Powell argued, was a, quote, response to a situation in which the Constitution's most important interpreters, not just a few crackpots here and there, but a majority of justices of the Supreme Court of the United States, quote, could present the logic of the Eisenstadt opinion as though it were a respectable legal argument, rather than a non sequitur that revealed a sort of contempt for the notion of reasoned decision, and for the litigants, lawyers, and general public for whom the opinion was supposed to explain the court's decision. This brings us to a second piece of writing by Judge Bork, his 1996 essay on the end of democracy in First Things. This essay was published 25 years after Neutral Principles, a quarter century in which many new justices had been appointed, but in which the Supreme Court had, in Bork's view, only strayed further from the original Constitution, doubling down on the errors of the Warren and Burger courts. And so, he concluded, this tendency of courts was the inevitable result of our written Constitution and the power of judicial review. Power corrupts, and unchecked judicial power will inevitably lead to unchecked abuse. To halt the transformation of our society and culture by judges, he suggested a constitutional amendment to ban judicial review, or alternatively to allow Congress to override the courts. Or in the last need, it may be that elected officials should simply refuse to comply with their decisions. In other words, this anticipated the various positions of Professors Moyne, Dorfler, and Seidman many years later, proposing populist, majoritarian solutions to the defects of a credentialed judicial elite, yet solutions that, as were acknowledged, carried serious costs and dangers of their own. Looking back on this essay 25 years later, one sees immediately that the arrow of history does not always point in the same direction. Roe has been overruled, the courts are plainly more originalist than they used to be, attitudes toward acceptable forms of judging have been transformed. At no time in recent history has the Federalist Society's position, that it is the province and duty of the judiciary to say what the law is and not what it should be, been more widely echoed and accepted. But in other ways, the situation is far more grave. The sorts of institutional failures that Bork saw in the courts, and to which he proposed legislative overrides as a populist and majoritarian solution, have been revealed in a wide range of institutions. These institutions are often run by folks with impeccable credentials, by which I mean the socially recognized indicators of unusual skill, knowledge, or experience. And yet, for all their elite credentials, in many fields, they've done a pretty lousy job. We have a public health establishment that's lost public confidence on vitally important matters, having exaggerated some dangers and underemphasized others. We have educational institutions that have sought ever more funding, but have failed to maintain effective literacy levels over time. We have a national press that too often fails to inform, or indeed often leaves one knowing less, and so on and on and on. I am sure that everyone in the audience here could recite his or her own litany of institutional failures. In too many areas, the credentialed, the adults in the room, have not acted wisely or well. And yet, in failing to act wisely or well, they have acted in predictable, politicized, and culturally insular ways. Again, I do not need to remind you of the examples. The concern here is not merely that our credentialed class is performing less well, but that this is both cause and symptom of a growing social and political division between those who are members of this credentialed class and those who are not. And this new source of division poses a second problem, both for society and for constitutionalism, and I would like to discuss both. Let's start with society. Per recent polls, fewer people say that it would matter to them if a family member married someone of another race than if that family member married someone who voted for the other party. Now, this is based on what people will admit to a pollster, and it does not suggest by any means that party identification is more salient to Americans today than race. But while greater interracial understanding is extraordinarily welcome, this cultural division along party lines does represent something new, and in my view, very worrisome. As we have seen in the last election, our politics are becoming somewhat less polarized by our existing divisions of race and ethnicity, and somewhat more polarized by gender and especially by class. Not income necessarily, but by education and by a certain kind of social position. The sorts of people, like me, who have college or indeed postgraduate degrees, people who work in culturally influential institutions like universities, people who live in zip codes where a Whole Foods is to be found, these folks have to some extent come apart socially and politically from those who do not. And the more politically insular the institutions staffed by such people are, the easier it is for politics to affect their judgment, since after all, everyone around you and everyone you know thinks pretty much the same thing. So trusting these institutions leads one in a more polarized and insular direction, because it leads to distrust of all those who would contradict them. And the same is true on the other side, because distrusting those institutions, which is often the mark of a crank, encourages one to seek out fellow cranks who will helpfully affirm one's own views. This cycle of political polarization makes effective government correction, not any correction at all, but effective correction, that much more difficult. In the words of essayist Scott Alexander, from whom the next few paragraphs are a quote, elites have enough advantages in power, connections, education, and so on that in the natural course of events, they always come out on top. Trying to come up with a system where elites don't come out on top is an almost futile task, one where you will be constantly pumping against entropy. The normal course of politics is various coalitions of elites and populace, each drawing from their own power bases. A normal political party, like a normal anything else, has elite leaders, analysts, propagandists, and managers, plus populist foot soldiers. Then there's an election, and sometimes your elites get in, and sometimes their elites get in. But getting a political party that's against the elites is really hard, and usually the sort of thing that gets claimed rather than accomplished, because elites rise to the top of everything. But sometimes political parties can run on an explicitly anti-elite platform. In theory, this sounds good. Nobody wants to be elitist. In practice, this often gets really nasty quickly. Democracy is a pure numbers game, so it's hard for the elites to control. The populace can genuinely seize the reins of democracy if it really wants. But if that happens, the government will be arrayed against every other institution in the nation. Elites rise to the top of everything: media, academia, culture. So all of those institutions will hate the new government and be hated by it in turn. Close quote. Now, fixing that division, that separation of the credentialed class from others and the flaws in that credentialed class, requires just the sorts of skill, knowledge, and expertise that we usually rely on those very credentials to establish. And the emerging social divisions mean that those who have credentials will often be primarily on one side of the political divide. Those on the other side will then naturally be suspicious of those who claim to be traitors to the credentialed class. And they may be willing to take a flyer or two on other, less well-documented claims to expertise. Again, I do not have to remind you of examples. There are no easy answers here. In an ideal world, I would want university curricula to be set by faculties and not by state legislatures. That is why, after all, the majorities who fund those universities want faculty members to teach there, rather than taking turns teaching the classes themselves. But in the world in which we actually live, in which faculties often are not minding the store, someone has to be responsible for the public fisc. And in practice, that means elevating majoritarian decision-making with all of its flaws and all of its dangers. Indeed, one of the most serious consequences of the polarization of the credentialed class is that society really needs credentials that it can trust, even or especially on politically sensitive matters. When one can't rely on the judgment of news editors, it just takes too much work for everyone to sift through all the available information to decide what's going on. I know because I spend time curating my Twitter feed, and I still am not sure that I'm fully informed. When one can't rely on the judgment of schools of education, it just takes too much work for everyone to learn about pedagogy or curriculum design to teach their own kids at home. When one can't rely on the judgment of the public health establishment, it just takes too much work for everyone to do their own research and decide how best to protect their families and others, and so on. Unusual skill, knowledge, and expertise in different domains are always going to be in limited supply. And sometimes we need social indicators that reliably help us see those things in others without having to supply them for ourselves. Now, it may seem somewhat rich to have me here speaking to you in defense of needing credentials. I am a fancy pants tenured professor. I am even wearing tweed. But it does not take much history to know that good things are easier to destroy than to create, that being hated by all the right people is not always a marker of good character or good judgment, and that the result of burning it all down is too often dust and ashes. The point of a controlled demolition is not just to create a gaping pit in the ground. It is to build something better in its place, and it is important that those put in charge of the former also know how to do the latter. Now turn from the problem that this new division poses for society to the problem it poses for constitutionalism. The task of our current era will be overcoming these social and political divisions so that we can have better institutions rather than no institutions at all. For in the meantime, these very divisions make it harder for us to rely on our constitutional mechanisms for keeping a divided society together. FedSoc does not support or oppose nominees, and I will not do so here either. But I will note that, according to current reporting, a number of candidates for nomination to an important government post, quote, talked about their vaunted legal theories and constitutional stuff. This is the expurgated version because this is a family conference. While the successful candidate, quote, was the only one who said, yeah, I'll go over there and start cutting expletive heads. I have no idea whether this is true or who these candidates were, but I will say that adherence to vaunted legal theories is in fact a crucial asset in many government posts to help restrain the temptation for abuse when it inevitably arises. And just because you're on one side of a deep political divide and the other side seems extremely objectionable does not mean that everything done in service of your side will be wise or just. There is no simple answer as to how many risks to take. Everything depends on the facts and the context. But some risks can be worth running and others not, and part of the prudence required of government decision makers is the ability to tell the difference. Over the next several years, there are decisions that will have to be made, sometimes by people now sitting in this room, about how best to serve the country and how best to defend the Constitution, in circumstances where departures may seem very tempting. And when the illusion of permanent victory beckons, vaunted legal theories can often be quite necessary in keeping ourselves grounded and keeping our modus vivendi going. Indeed, what made a version of Judge Bork's originalism so successful over the last 25 years was not just the force of political victories or even just historical accidents, which justices were appointed when and so forth. There were plenty of Republican election victories and appointees to the Warren, Burger, and Rehnquist courts, and unfortunately few of them were accomplished originalists. Instead, what made originalism successful, such that even Justices Kagan and Jackson would acknowledge its authority in their confirmation hearings, was precisely that it has been so convincing to many as a matter of vaunted legal theory, that it is not just a list of results that successful candidates might write into the Constitution, something anybody can produce, but a coherent account of what might actually follow from the Constitution we actually have. And FedSoc, in its own way, has been a challenge to the insular nature of the credentialed class by serving as a form of credentialing institution of its own. People give speeches to student chapters or take part in panel discussions, and other people hear them and pass it on. Oh, that person was really insightful. They seem to know what they were talking about. The claimed list of FedSoc judges in 2016 was in no way a product of the Federalist Society, the organization, but it was an indirect result of the sort of information that the Federalist Society has managed to surface in a decentralized way over the last several decades, without judges needing particular fancy pants degrees or, God forbid, high ratings from the American Bar Association. So that is why I do not see the answer to these various challenges that face us today as FedSoc speaking out on political matters, even important ones, any more than the answer, as someone jokingly suggested online, is another strongly worded letter from law school deans. In our current moment, efforts to deploy institutional trust for political ends tend not only to fail, but to fail badly, to politicize the institutions and to destroy the original basis on which their trust was earned. Rather, part of why FedSoc is able to serve the role that it does is precisely that it tries not to get involved in day-to-day politics, that it doesn't have detailed articles of faith and doesn't take positions on litigation, that it lets people of a variety of conservative and libertarian convictions and habits, even us tweed wearers, make their arguments to each other and see whom they can convince. In reforming our flawed institutions, it is this spirit of open competition that we so desperately need. It will require government action, that is true, but action to open up institutions rather than simply to crush them. It may mean new universities and cultural institutions to compete with those in existence now. It may mean new programs at existing universities on the model of the Hoover Institution or on the model of the civic centers now emerging at a number of state universities today. It may mean new accreditation agencies or other government policies to open the channels for alternative schools, alternative companies, alternative industries. But whatever it involves, it will require a commitment not just to denying the claims to expertise of the credentialing institutions we have, albeit flawed, but to put in real efforts to building better ones in their place. In this same spirit, that open channels for competition often serve us best, that, as FedSoc's mission statement would have it, government exists to preserve liberty, and that our greatest task is to allow those who best know their own needs to pursue their own good and honorable lives, is also what allows our Constitution to serve as a modus vivendi among different groups of people, many of whom disagree on deep matters of importance, but who have not, at least not recently, come to blows nevertheless. Thank you.
I'd just like to say thank you to the professor. I love his tweed. Where do you get that? And to give him a bust of my father, which I hope you will display prominently, or maybe at Harvard, not so much. I don't know.
I will, I promise. Thank you so much.